We'll we'll discuss some other questions such as explain assault and battery with relevant leading cases, then discuss the essential contribution of tort of defamation and the various defenses available to the defendant. What is defamation? Briefly discuss the different conditions which will be required to constitute an action for defamation with the help of leading cases. Then, what are the kinds of defamation? Distinguish between libel and slander. And regarding all these questions, already we have uploaded several videos before this, and now we'll just briefly discuss what is assault and what is battery. So, assault is a kind of creating apprehension of fear regarding use of force to another. For example, showing or pointing a gun at another, or by taking a stick in the hand to create apprehension of use of that stick to beat another, such are considered as assault, and these are considered as offense under Section 151 of IPC, while battery is the actual use of that threat, or by actually you touch another by that. Suppose that stick which you are showing to beat someone, and if once the very stick touch that person, then it causes battery, and which is also an offense under Section 350 of Indian Penal Code. And regarding defamation, it is also an offense under Section 499 of Indian Penal Code, and defamation constitutes two kinds. One is libel and the second one is slander. And as per libel, libel is a kind of publication of a false and defamatory statement, and that regarding that one we would like to discuss a leading case, that is Rasputin, the old monk, and it was a film produced by the MGM Pictures in Russia, and it was showing that the Princess Irina of Russia was seduced by the monk, and so Princess Irina challenged this film producer on defamation of libel. And while slander means it is a kind of verbal or oral false and defamatory statement, so both libel and slander is a civil wrong and a criminal offense. Slander is only a civil wrong, but when it becomes seditious or offense, or it is regarding contempt of court, etc., then it became a criminal offense. And in India, slander is both a tort and a crime, and those defenses provided regarding defamation, one is justification. That means that what statement you gave, either in the form of libel or slander, it is in fact true. And the second defense, that is the statement one made, is must be fair and bona fide comment. And as it is regarding public interest to have given certain parent bona fide in comment, as in case of criticism of work of literature, art, etc. And also another defense available is the privilege, and that privilege which is available under Article 105 and Article 194, irrespective to the members of parliament and the members of legislative assemblies, and also all the judicial proceedings that held in court of law are also the defenses available in case of this. So now we'll go to the other one, that is explain false imprisonment and malicious prosecution, distinguish the two with important leading cases. So false imprisonment is a kind of wrongful confinement or wrongful restraint or arresting or detaining any person unlawfully, and as wrongful restraint it is an offense under section 339 of Indian Penal Code, and as regarding wrongful confinement of a person, it is an offense under section 340 of Indian Penal Code. And in relation to that, we would like to discuss a leading case, and that is Banner versus Marvel Hotels 1970. And in the very fact of the case, the very bill tendered by the hotel was disputed by the petitioner, and he did not pay the bill, and in regard to that he gave his name and address to the hotelier, but the hotelier, in spite of that, he kept detained that guest. So here Werner challenged his detention, and the court held that this is a kind of false imprisonment, as already he has given his name and address, so he could not be detained. And regarding those defenses available regarding false imprisonment, that is of self-defense or preventing breach of peace or any escape from lawful custody or confinement of lunatics or assisting officers of law or parental authority or ministerial officers and judicial authorities and their actions are false under those defenses regarding false imprisonment. And now we'll go to malicious prosecution, which means that when you set the law in motion with malicious spirit or improper motive without reasonable and probable cause, and all these kind of attempt or acts which makes the law in motion with malicious spirit or improper motive without reasonable and probable cause, it all cause malicious prosecution. And regarding that, we will discuss a leading case, CM Agarwal versus Halal Salt and Chemical Work of 1977. The Calcutta High Court find out that in case of malicious prosecution of a person, There three things are derived. One is damage to person, damage to his reputation, so also damage to his pocket. So these are the damages caused to a person by a proceeding wrongly set in motion by another persons with malicious spirit or improper motive is called malicious prosecution. And now we'll discuss regarding slander. And as Salman defined it, nuisance is either due to escape of water, smoke, smell, fumes, gas, noise, heat, or vibration, or disease, or any germ, etc., without lawful justification by one person from his land to others, and which caused unjustified nuisance or disturbance. And regarding the very definition of nuisance as given by Professor Winfield, it is an unlawful interference in the use or enjoyment or the right of a person by one's unjustified, unlawful action. And regarding that, we will discuss a leading case, and that is Ushaben Trivedi versus Bhagyalakshmi Chitra Mandir, 1978. The Gujarat High Court expressed that nuisance is an injurious action by the defendant regarding the health and offending the senses, which causing annoyance and discomfort to another. And so also in another leading case, that is S. Chittiar versus Sri Ram Kumar, in 1987, the Madras High Court held that all those factories which produce bricks, so also by that they causing annoyance and also discomfort in the locality, so it is a kind of nuisance. So also in another leading case, V. Venkatappa versus B. Lovis, in 1986, Andhra Pradesh High Court also held that the very smoke which is emanating from the chimney of a house is also falling under nuisance, as it is causing annoyance and discomfort among others in the locality. And as regarding nuisance, as such public nuisance and that causes common injury or annoyance to people in general, such as a common game house or a disorderly inn or obstruction of the highway or public road, etc. And regarding private nuisance, it is an unauthorized use of one's own land or property or unauthorized interference to another's property, such as obstruction of light, air, wrongful escape of foul gas, noise, germs, water, etc., causing annoyance and discomfort to your neighbor or to another person, and it all falls under private nuisance.